significant development, Nigeria has achieved a preliminary success in its legal efforts to overturn a 2018 UK default judgment that imposed a $15 million fine in favour of British-Nigerian businessman Louis Williams. The High Court in London dismissed Williams' application to strike out Nigeria's fraud-based challenge, allowing the case to proceed. And this ruling marks a crucial step for Nigeria as it seeks to contest the judgment on grounds of alleged fraud. Liborous Oshoma, lawyer and public affairs analyst, joins me now. It's a pleasure to have you in.
Yeah, thank you, Joanna.
Yes, looking at how the AFG has described this case, he says this demonstrates that the nation would never again be exploited. Is that how you're also, describing this case? And would you say we are in a position, we have learnt our lessons and put ourselves in a position not to be exploited?
Yeah, thank you for your hydra-headed question. I think we have learnt our lessons. But whether we have put in a position not to be exploited is a debate, an ongoing debate, and it will go on for a long time, because I don't think that we have put ourselves in that position. Can you hear me? I don't know if you can hear me.
Yes, I can. You have said that you don't think we have put ourselves in that position not to be exploited again. And I'm wondering,
yes,
what do you assume it will take to put ourselves in that position so that we will not be exploited again?
Yes, like I said, we have not, because our attitude to some of these things, it's very slow and laid back. You find out that this judgment was a default judgment. By default judgment means a judgment entered into without the appearance of the other party. That's what we call default judgment. And so you saw the P&ID case. What also happened was that we were laid back. You also saw the Chinese case with the default judgment at the Chinese company that had to do with the free trade zone in Ogun State got against the federal government. It was because also we didn't take proactive measures, we were laid back. So this default judgment by Williams also showed that, people just sat back and processes were filed against us, and, nothing was done until a judgment was entered in absence of our appearance. So if you look at, most of the cases, I don't think that the response that we need to actually deal with these cases, we are giving it that the speed that it requires. That's why I said, even though we have learned our lesson, but I don't think that we are putting ourselves in a place where we would say, look, we can no longer be exploited. And then coming to the issue of exploitation, this matter, if you look at the story of the matter, what Nigerian government is claiming now is, fraud. They're alleging fraud. That all the documents that Mr. Williams used to obtain judgment were, fabricated documents, that he actually didn't lose money, and that also this document that he claimed were later found that they were from the then Attorney General Clement Akpangbo, and that they were found in a private law firm. So at what did Nigeria investigate this fraud? Even though the court noted that point, that at what time did we become aware of this fraud? And in 1996, we didn't, in 2019 also, we did not allege fraud. Even in 2022, we didn't allege fraud. So these are very grave, allegations. And that's why the court feels that certainly the matter will go for trial, but that since we're alleging fraud, even though it is belated, but that there is room for us to prove those fraud. So if you look at all of the gamuts of those issues and if you juxtapose them with some of the activities that happens in our ministries, parastatals and agencies, you will say that even though we learn these lessons every day, but we have really not been able to clean up our system to ensure that we are not exploited. What we are basically doing is that we are reacting. We are not being proactive.
And I mean, I assume you've already explained how Nigeria was able to convince the UK court, or can you let us into that? How were we able to convince the UK court that the $15 million arbitration ruling deserved a second look? And what specific concerns do you think were raised?
Yeah, in any matter that is, in any judgment that is a default judgment, especially, mind you, like I said, a default judgment, there's lack of appearance on the part of the other side. And since one of the twin pillars of natural justice is that you must hear the other side. So the tendency for the courts to always want to hear you when you are applying to vacate a default judgment is always, very high. And the one thing that has saved Nigeria is that we have pleaded fraud, that, these documents were fraudulent, and that there was the man did not, lose that money that is claiming to have lost. So that's why the court said, well, even though our application is belated, these allegations are weighty. And the fact that the man is, Mr. Williams is claiming that the sting operation actually cost him to lose that money, and that there were bank guarantees to this transaction. All of these allegations are allegations that would need trial, that the court will need Mr. Williams to go into the trial witness box to testify and tender document. Since judgment was delivered without actually going through the rigors of trial. So the court, in its wisdom, against the principles of natural justice or the other pattern, that means hearing the other side, decided to give Nigerian a second chance and say, okay, I would dismiss the application to vacate your claim, but also let's give you opportunity to see if you truly have a claim, and then Nigeria would subsequently defend. I think it's on that ground, basically on the ground of natural justice, that the court decided to give Nigeria a second chance.
Yes, interesting. I mean, we'll see how this goes on. But another thing that was said is that this is a powerful message to the world that Nigeria will not be exploited. In terms of messaging, what does this victory send to those looking to do deals with Nigeria? You explain why you're laughing, but what does this message pass to those looking to do deals with Nigeria, in Nigeria, seeking contracts and so on and so forth? What is the lesson on that side?
Yeah, first and foremost, I like the fact that I must give kudos to the Minister of Interior, who was Olubunmi Ojo, who has put in, a lot of innovative ideas as regards automating our system, our processes, to ensure that anybody coming into Nigeria, information and data are captured succinctly and verifiable, address and transactions. But that said, why was I laughing? I was laughing because apart from, this Minister of Interior, which other parastatal, you can talk about maybe, CBN and Minister of Finance, but most of these processes are automated now. But most of the transactions with state government, mind you, some of these transactions, there are some transactions that originate from state governments that eventually, because you can't still sue the state government in international, courts, you will take the claim out against the Nigerian government. Most of the transactions at the state level, especially some of these loans that we are taking, how many of them, are captured, in automation systems like this? Mind you, here we are. Clement Akpangbo is the Attorney General at that time. IBB is alive, but basically, certainly the documents, some of these documents were automated. And if you speak for the Ministry of Justice, how many of their files these days are automated? And transactions and agreements, if the set of leaders that we have today lived, can we, in all honesty, with the click of the button, BS, some of those transactions that, they are signing today? That's another big problem. That's why I was laughing. So it's not enough for us to make big and bogus statements to say, yes, we are showing the world that we can no longer be exploited with this kind of reaction that we are reacting. When the matter was in court, we were no steps. I want to see proactive measures put in place to ensure that when you are doing business with Nigeria, any business that you're going to do, that even if this set of leaders leave the office tomorrow, with a click of the buttons, all the documents would be found. They will not be in some private law firms or in some public law firms or in the Ministry of Justice. All of them can be collated. And the individuals, I can say yes, for the individuals, with what the Ministry of Interior has done, yes, you can say you can track and trace individuals. even with the automation of our passports these days, fantastic idea. But we need to go the whole hog before we can truly come out and begin to beat our chest to say, yes, you can no longer exploit us. Because as it is now, we are still very vulnerable and, subject to exploitation.
So a lot more needs to be done. Hopefully this doesn't...
Quickly, let me add this. You find out also, most of the companies warehousing data for Nigerian government, Nigerian businesses, a lot of them are not here. So when your data are in the hands of foreigners, how then can you say you are not vulnerable? So I just needed to add that. Thank you.
That's another conversation that definitely needs to be had, and perhaps we'll have that conversation some other time. But sticking with this case and this supposed victory, how big of a bullet did Nigeria dodge, right? What could we have lost if we did lose this case? And what have we gained, aside the lessons financially? What are some of the gains awarded by the court?
Yeah, on two occasions, if you look at the analysis and the story, on two occasions, a president in Nigeria, that of IBB, there was an allegation by Mr. Williams that the then president, Ibrahim Badamasi Babangida, did enter into an agreement that the fund should be paid to him with compound interest at, I think, 17% And you imagine somebody, if truly the allegation of fraud is true, imagine somebody going home with that amount, $60 million, from our coffers, and interest on that money from 1993. So then now come to Yar'Adua's tenure administration. Also, there were allegations that Yar'Adua entered into an agreement to pay the money, and until investigations revealed that the documents tendered and the purported agreement with IBB, allegedly signed by Oziuba Ahmed, who was CBN governor then, were all fake. And so imagine if we had, paid that money with interest running from that time. It will run into not just the $60 million, but almost $1 billion. And then coming to this time, and then you have such a default judgment and you want to execute. Now that Nigeria is crying of a scarcity of forests, imagine executing such a judgment against Nigeria. Now that we're even borrowing, to do a lot of the things that we're doing. So we dodged not just a bullet, but a bomb. And kudos to the team. I must also commend them. Kudos to the team that were able to investigate and discover that these documents were actually fraudulent. Because the story of Dr. Williams is truly inconsistent. So kudos to the team also. I can't just, give them knocks here. But the fact that they've been able, because the court, was of the view that in 2016, the issue of fraud was not raised. In 2022, the issue of fraud was not raised. They just raised the issue of fraud in 2024. So kudos to the team for discovering that one. And let us wait to see how they are able to prove that during trial.
And I mean, you're a legal practitioner yourself. You just spoke on the legal strategy. What would you say stands out in their legal strategy in the handling of this case?
Like I said, there were the previous handlers of the case were not proactive. They were not I didn't see efforts. But this team, what stood out for me is the fact that they were able to probably take the documents through a forensic analysis, because forensic analysis will reveal if truly indeed the original documents and the bank drafts or bank guarantees actually existed, or if the agreement reached by the then CBN governor with Mr. Williams actually were agreement reached on the basis of existing, transaction that was not fraught with fraudulent documents. So that's a whole lot of work. So I would salute their industry in that regard, because the strategy, once you allege fraud and you are able to prove fraud, Nigeria will go scot-free. I will not pay that money. I might even be seeking damages from Mr. Williams.
Interesting. We'll see how this pans out. Now, we know that this is an initial victory. How would you say that this has given them stronger credibility or legal leverage in the new case?
I don't think there's... the only leverage it gives them is that, yes, there is allegation of fraud. And I hope it's not a smoke screen. like the court has said, why didn't you raise this all the while? But the director of civil litigation that deposed to the affidavit, Joanne, did say that the allegation of fraud came to their notice, just recently. And I just hope it's not a smokescreen. And if it is not a smokescreen, and the opportunity for trial is presented, like the court had noted, opportunity for trial is presented, and that will also afford, the courts to take those documents through carbon dating with forensic analysis, and then opportunity for Nigeria to, like I said, present its own side of the story. So that strategy really, once there is fraud and fraud is proven, then the strategy would work. But there were some remarks noted by the court. How come that with the capacity to investigate fraud all of the while, why didn't the Nigerian government also initiate processes or report, to investigate this fraud? Why, is this coming up all of a sudden? And in law, we call it leches and acquiescence. So if it is also established that you acquiesce, even though there is no limitation to fraudulent matters, but also acquiescence can, mitigate the remedy that you get, on the side of the defense. So that strategy would work if truly, they are able to prove that this allegation of fraud truly, other parties that had handled the matter before, it didn't come to their knowledge. And but the court will not be looking at who had been handling it, because government is continuum. So the court will look at, what actions we are taking. But I will not say it's not yet a uhuru for Nigeria. Like I said, I hope it's not a smoke screen. But I hope that the allegation of fraud had been thoroughly investigated and all the documents taken through a deep forensic analysis, and that the allegations are top notch.
All right, so
it's done. I can bet you that, then it will be uhuru. That strategy would work. But until then, we can just cross our fingers and hope for the best.
So we shouldn't get carried away with celebrations just yet. It'll be interesting to trail this with you, and hopefully we can have you come.
No, not at all.
Hopefully we can have you share more of your thoughts. Liborous Oshoma, lawyer and public affairs analyst. We dodged more than just a bullet, a bomb, apparently. But that's it on the first conversation. We're taking a break right now. Thank you for joining us, Liborous.